We are reading Gilbert Law Summaries, Publication of Legal Research, Writing, and Analysis, which is why in Chapter 9 of the, which edition? The 11th edition, starting on page 83, we're reading and understanding a case is the title of this chapter, and it includes the introduction to case analysis and a sample brief. So in general, under subpart A, introduction to case analysis, in general, finding a case is only the beginning. The real problem and the place where most people find themselves stymied is in reading and understanding the case they have found. What are the highlights of the decision? The most important points. What are the facts? What issues did the court consider, and how did it resolve these issues? In law school, the method of separating the wheat from the chaff of a decision is called briefing a case. Number 2 under section A, Introduction to Case Analysis, is titled Briefing Cases. As the word implies, a brief is a concise outline of a court decision. This term brief should not be confused with a brief filed by an attorney in a court. A brief is, in the latter context, is a forceful representation of the issues and law involved in the client's case. It is designed to persuade the court to decide in the client's favor. Briefing a case helps you organize your thoughts and determine what the court is actually saying. Because many court opinions are long-winded and often shrouded in legal terms, briefing is a most difficult skill than first imagined. It is not surprising to find that many law students and even lawyers still misread cases and jumble their analysis of the law on the subject under investigation. Without this skill, you will never be very effective in doing legal research and writing. There are several times when you should brief a case. The first and most important is to help you understand what is going on. It is to this concern that we have written this chapter. In doing research, a good brief will cut down your time measurably. You will not have to go back and read the case again because you cannot remember what it said and your notes are all jumbled. It will also make it simpler for you to be well organized in preparing your own case in court or at an administrative hearing. Remember, a brief is just that. It is designed to give the reader insight into basic points of the case, no more. It's not supposed to talk about all of the points of the case, just basic points of the case. If the reader is interested in knowing more, she can always look up the case. Following our discussion on briefing a case, we reprint an actual decision on the United States Supreme Court, in the hope that you will first try to brief this case yourself. We will conclude the chapter with a brief of the case. A. Suggested format. This is the outline we will use in briefing a case. 1. Name and citation. 2. Court. 3. Judicial history. 4. Facts. 5. Issue. 6. Holdings. 7. Reasoning. 8. Decision, and 9. Concurring opinions, and 10. Dissenting opinions. That's interesting. To help illustrate the writing of a brief, we will work with a simple set of facts from a fictitious case. This fictitious case has really hard names to pronounce. Lafcadio Hearn's landlord, Knut Hamsun, has not repaired the broken toilet in Hearn's apartment. Hearn decides not to pay rent until Hampson fixes it. 10 days after the rent is due and unpaid, Hampson sues to evict Hearn in the state's trial court. In court, Hearn argues that he should not have to pay rent when the place is uninhabitable. The trial judge rules in favor of Hampson, saying that although he may sympathize with Hearn, there is no state statute allowing this kind of rent withholding. Hearn appeals to the State Court of Appeals, which agrees with the trial court. Hearn now appeals to the state Supreme Court for an actual decision dealing with a similar set of facts and law. See Green v. Superior Court and some California Reporter. So B, the name and citation including the year. The name of the case is usually two names separated by the abbreviation V, which stands for versus. The name of our case is Hampson v. Hearn. The case name is either underlined or in italics. First names are not used unless they are part of an organization's full name or title. For example, Joe Rothfund v. San Francisco Gazette. It is not necessary to add the names of other plaintiffs and defendants involved in the case, nor even to use the Latin phrase at all to indicate their existence. The name of the case is only a means of identification. If someone is interested in the other parties of the case, he can look it up. Give all the citations, official and unofficial, the official appearing first. Citations are discussed in earlier sections. The year of the decision followed the citations. Be sure to include it. It makes a difference whether the case was decided in 1959 or 2001. Court. Always note the court that rendered the decision. Because there is a hierarchy in our court system, a decision by one court may be more important than a decision by another. To understand the full effect of the decision, that is, its precedential value, it is necessary to know whether the highest court, an appellate court, or a trial court issued it. Be sure to give the precise name of the court to avoid any confusion. In our example, we are in the state Supreme Court. Judicial history. The judicial history, often referred to as the procedural posture of the case, is the history prior to where the case is now. It considers questions such as, what was the plaintiff asking for when he first brought the case? That is, what judicial relief did he want? Sometimes the defendant may not only defend the action but also bring his own lawsuit or claim against the plaintiff in the same action. The defendant's affirmative suit against the plaintiff is called a counterclaim or a cross-complaint, depending on the jurisdiction. What happened to the case in the lower courts? What decisions were made on the rights of the parties? A judicial history of our example would read, plaintiff landlord brought action to evict defendant tenant for non-payment of rent and to recover the rent due. Trial court ruled in favor of plaintiff, as did Court of Appeals. Defendant appealed to the state Supreme Court. Facts. We cannot overemphasize the importance of facts. Everything else is determined by them. Had the facts been different, even slightly, the issues, the holdings, the reasonings, and the decision would likely have been different. In reading a case, pay close attention to the presentation of the facts. Which facts does the court consider important, and which does the court pass over? The seed of the decision lies on the facts. Read the case through. Often you cannot tell which facts the court considered essential to the decision until you have read the entire case. Then, in briefing, you will be able to glean the most important points so that you will not find yourself overwriting. No matter how long and detailed the facts are in a case, you can usually filter them down to a few sentences. People who begin writing briefs usually write too many facts. Remember, a brief is only an outline. Someone who is interested in every detail can always go and read the case. The facts of our case would be, landlord did not repair a broken toilet in tenant's apartment. The tenant claimed the place was uninhabitable and refused to pay rent until the landlord made the repairs. As you gain experience in reading cases, you will see how judges play around with a set of facts, manipulating them to reach a desired decision. They will try to make the plaintiff or defendant an object of sympathy, depending on whom they think should win. Often one judge on the appellate court will emphasize one fact while another judge will emphasize another. Basing their decisions on the facts, the two judges will then reach different conclusions. Judges also play around with facts when looking at earlier, possibly precedent setting cases. If a judge agrees with the decision of an earlier case, she will often say that the facts of the earlier case are similar to the facts in the present case and hence will reach a similar decision. If the judge disagrees and the earlier decision, she may distinguish the earlier case on its facts and conclude that the earlier decision would not apply in the present case. The judge will then decide her case differently. The clever attorney will thus present the facts of his case in a way to be similar as possible to those of an earlier decided case in which the outcome is the same as that which the attorney wishes to reach now. Letter F, issue. The issue is the principle of law the court is considering. It is strictly determined by the facts of the case. If the facts were different, the issue would likely be different. The issue is presumed as a question of law. It may be written in terms of the particular facts of the case or in general terms. In our example, the issue in specific terms would read, can a tenant withhold his rent until the landlord repairs the toilet? In general terms, it might read, can a tenant withhold his rent until the landlord brings the place up to a habitable condition? The problem with writing an issue in general terms is that it may reach too far. For example, in our case, what is habitability? Does a broken stove mean the place is uninhabitable? What about a broken shelf or a broken drawer? Because cases are interpreted in different ways by different lawyers and judges, a general issue has much more chance of being inaccurate or misleading. Nevertheless, because law needs to establish precedent, a decision must necessarily yield a principle of law somewhat larger than a statement just to the particular facts of the case. But the question is, how much larger? It differs with each decision, how broad or narrow the judge tries to make it, and with how judges in later cases interpret the decision by expanding or constricting it. You should begin by constructing issues in terms of the specific facts. This will give you a clear understanding of the case. It will be easier later for you to expand the specific issue into a general one without overextending the principle, once you have grasped the import and direction of the case. There may be more than one issue in a case. Rarely there are more than 2 or 3. A court can usually make its decision and dispose of the case after deciding 1 or 2 points of law raised by the issues. Other issues raised by the parties need not then be considered. In briefing a case, only give the issues that are actually decided by the court and are necessary to the decision. Remember, as we noted in Chapter 3, the head notes to the case refer to many more principles of law than are actually raised by the issues in the case and decided by the court. Holdings. G, letter G. A holding answers the question and settles the principle of law raised by an issue. There is a holding for each issue. Holdings, like issues, may be written in general or specific terms. Here, too, we suggest you begin with a specific holding, one in terms of the particular facts of the case. Then, when you have a good understanding of the decision, you can expand the holding to a more general one, being careful not to overbroaden it. A general holding has more value since it covers more than your specific fact situation. However, later courts dealing with similar situations will determine precisely how broad or narrow the range of the holding should be. The specific holding in our case would be, the tenant can withhold his rent until the landlord repairs the toilet. In general terms, it might read, a tenant can raise a defense of warranty of habitability and withhold his rent until the landlord makes the necessary repairs to bring the place up to a habitable condition. Since most courts can decide a case by resolving only one or a few issues, you will rarely find a case with more than 2 or 3 necessary holdings. When a court discusses additional incidental points of law, points not necessary to the decision, it is reciting dicta. A principle of law stated in dicta is not binding precedent on later courts, only a holding is. If you are having trouble determining the holdings of the case, do not rely on what the head notes to the case say. Most of the principles in the headnotes are dicta. Instead, go back to your issues. Remember, your holdings must answer the question of law raised by your issues. There are only as many holdings as there are issues, and there are only as many sets of issues and holdings as are needed to dispose of the case. H. Reasoning. A judge may give reasons for the holding. She must show that the holding was arrived at thoughtfully and logically, and that it is consistent with earlier cases. Our system of law is based on these premises. Even judges who from the first know which way they will decide a case understand that explanations must be given to support their decision. In our example, the reasonings would include the old law requiring tenants to pay rent regardless of the condition of the place dates back to an agricultural era, when leases were for land, the house being merely incidental. The farmer could usually make the necessary repairs. Today, leases are largely for urban dwellings, and the tenant lacks the skills or finances to make the sophisticated repairs. In other consumer contracts, the law recognizes implied warranties and the rights of the consumer to enforce them. Because of the scarcity of low-rent housing, tenants have little bargaining power to negotiate for proper maintenance and repairs. Depending on the complexity and the importance of a case, 2 or 4 reasons are usually sufficient to support a holding. Remember, you need to give reasons for each holding in your brief. Letter I, decision. The word decision is often loosely and used interchangeably with opinion or case. The decision held that, but, quotations, but we will give it a narrower, more defined interpretation in our brief outline. The decision disposes of the case. It tells which party prevails. If the case is in a trial court, the judge will grant judgment in favor of the plaintiff or defendant. If the case is in a higher court, the decision will affirm, agree with the lower court ruling, reverse, disagree, modify, agree in part, disagree in part, vacate, annul, or remand, return it for further proceedings or a new trial. The precise words are usually found at the very end of the case. Note the difference between a holding, which establishes a principle of law, and a decision, which is concerned with the outcome and the parties. In our example, the decision would read, reversed and remanded. That is, the Supreme Court reversed the decision on the Court of Appeals and remanded the case back to the trial court for a new trial based on the law as established by the case. Letter J, concurring opinions. The court opinion we just briefed is the majority opinion. It is one with which a clear majority of the judges are in accord, but it is not always the only opinion you will see in a case. Often you will find judges who agree on the outcome of the case, the decision, but who disagree with the principle of law, the holding, that should be applied in reaching that decision. 1 or 2 judges may, for example, wish to narrow or broaden the extent of the holding. Or the judges may agree on the holding but disagree on the reasons for the holding. These judges who disagree with the holding or reasonings but agree with the decision may write concurring opinions explaining their differences. I just feel like I said the same thing twice. Often you'll find judges who agree on the outcome of the case, but who disagree with the principle of law. And here it says, these judges who disagree with the holdings or reasonings, but agree with the decisions, may write concurring opinions. I guess we were intending to say the same thing, just 2 different ways. Okay, there will be times when you find a case that, with no absolute majority opinion, that is, a majority of the members of the court cannot agree on the case holding. For example, in the United States Supreme Court case of Regents of the University of California versus Bake, 1978, 4 of the members of the court agreed on one point and 4 members agreed on another. The 9th member, Powell, voted with one set of 4 on one issue, and kinds of cases, each opinion will be given more concern than a concurring opinion in a case in which there is a clear majority opinion. The extent of the extent of noted concurring opinion in your brief depends upon its importance in the case. Where there is a clear majority opinion in the usual case, examine the concurring opinion for any additional insight it may give to the problem. If the problem is written by a learned, well-respected judge, it may merit more attention. And where there is no absolute majority opinion, each opinion should be considered. Where more judges join in one opinion than in another, but there is no majority opinion, the lead opinion is called the plurality opinion. Of course, where a concurring opinion discusses a point of law with which you are particularly concerned, you should note it. Usually, 2 or 3 sentences are sufficient to summarize a concurring opinion. K. Dissenting opinions. A dissenting opinion is one that disagrees with the decision and necessarily also with the holding reached by the majority of the members of the court. For example, the majority decision may be to affirm a lower court ruling, while the dissenting judges would reverse it. Although the law is determined by majority decisions, minority opinions serve an important purpose. Often they add to the understanding of the problem and expose the holes or weaknesses in the majority's position. In themselves, they may influence future courts or the legislature to change the law. Dissenting opinions may be ahead of their time or may tread behind. Of course, higher courts will at times reverse lower court decisions. Thus, a dissenting lower court judge may find herself vindicated later on. Just as with a concurring opinion and noted a dissent in your brief, you need only indicate the points of disagreement and any other information that would further your understanding of the case. If the dissent is a well-respected judge, or if you are concerned with the matter, perhaps agreeing with the dissent, you may wish to discuss the opinion in more detail. Usually 2 or 3 sentences will do. Number 3, reminder, read cases thoroughly. Before you begin briefing a case, read it all the way through, get a feel for it, see how the courts present the facts and resolve the issues. If you're unsure as to what is happening, read it again. If after the second time you're still uncertain as to what the court is saying, the problem may be the way the opinion is written rather than any failing on your part. People often have trouble expressing themselves in print, and judges are no exception. Do not ever rely on the head notes or the summary of a case. So the sample brief is subpart B, and under letter 1, the example case is explained. On the next several pages, we have reprinted an entire decision of the United States Supreme Court. Read the case through. Then prepare a brief for it using the recommended outline. After you have written your brief, compare it to the brief that follows the case. Remember, there is no magic way to write a brief. People's briefs are as different as people's use of words. As long as your brief is well organized and covers the main points of the case, you have done well. The following example is only to help you see whether you have gleaned the proper points. Your brief does not have to be precisely the same. So this is Bounds Correction Commissioner et al. Versus Smith et al. And this is a certiorari to the United States Court of Appeals for the 4th Circuit. And I'm actually going to end here because I've just done many briefings of so many cases by this point in time that I can't see this being a fruitful activity. So I'm going to pick in the next recording reading chapter 10.